This is Jonathan Kirsting with One Mic Stand, also with Tech Vibe Radio, and of course, the Pittsburgh Technology Council. I've been really enjoying bringing you these series, talking to some of the brightest minds here in Pittsburgh that I think just have great information to help you navigate not just the COVID pandemic, but it's almost like life in general. It's become more intensified because the pandemic has made us really scramble and act quickly. And it's just really just made things just, of course, nuts. But we have someone here that can help you make sense of a lot of this. Actually, talking about something that's really important, and it's kind of a tricky topic. I mean, it's all about like bankruptcies. I mean, it's happening to a lot of companies, and really looking at some of the best steps around that. We're talking to Beverly Manne here from Tucker Arensberg. Beverly, thanks for hanging out with us today. You've got a wealth of information that I think our listeners, our viewers here, can all get something out of, whether you're in trouble or not. This is good information to have, and I'm glad you're here to give it to us.
Well, thank you for having me. We have not seen the tide turn too much because I think people are in shock, but
Yes.
Usually what happens as businesses start to close or businesses don't get paid, it's usually a cycle, and it usually is sort of like a snake eating a cow. So as it goes around through the belly, it takes a while for it to get there. And what you see at a certain point is the businesses run out of cash. The businesses can't pay lenders. They can't pay lessors. They have issues. And that's when they get into, they're like, oh no, what am I going to do? But It's really important when you see this coming that you don't allow, you plan for it. You need to be in a position where you say, where's my cash? Where's my assets? What's my business plan? What happens if I stay shut for 30 days? What happens if I stay shut for 90 days?
Right. Don't say 90. Come on.
Hopefully the governor will allow Pennsylvania to open up, but a lot of our customers and clients, we're not just Pennsylvania centric. So the fact that we can't be open doesn't mean that we may not have critical clients in New York or some of the other states, because this is truly an international economy. We have clients with issues all over the world. And so one of the things you have to consider is what's your client base. So you have several issues that pop up. Can you get the supplies you need? Can you sell them? Can your clients pay you? What can I do with my financing? So that these are critical issues, but you have to look at it. You have to be prepared to say, what if it goes? Because it's not just that you're not open for 90 days, but if I start selling something today and I'm selling on an account receivable, usually it'll take me 30 to 60 days to collect that receivable. Exactly. So you're looking at how much cash do I need for at least 90 days, because some of your cash may not roll in for 60 to 90 days. So it's really critical when you're determining your business plan, where you go. We, in the workout and turnaround community, we talk about a 13-week cash flow. Do your 13-week cash flow, but at a minimum, that's what you're looking at. You should sit down, and the problem with a 13-week cash flow is it always assumed cash. Exactly. And I think we have a lot of businesses which have no cash. But on the converse side, we do have businesses which are in business. They're able to do things, but they have to be cautious, because if you're a business, it only takes one or two of your major customers to fail before you're in trouble. So even if you think you're doing well, if one of your customers isn't doing well, that creates some issues. Now, my experience at Tucker Arensberg, I'm the co-chair of the Insolvency and Creditors' Rights Department. And we do a lot of work, not just for credit. We do a lot of secured lending, unsecured lending. We do leases. We represent creditors, debtors, and we represent creditors committees. So we do this across the board. And we actually have a very experienced crew with respect to that. We even have a former bankruptcy judge as one of our partners, Judge Fitzgerald, who was here in the Western District of Pennsylvania, sat on the bench for over 25 years. And she also heard cases in the Virgin Islands as well as Delaware. And for our business community, Delaware is where a lot of the huge cases get filed, the mega billion-dollar cases. And she heard a lot of those. And she was on the bench during 9/11. She was on the bench during the financial crisis. And there are a lot of lessons that we've learned through those financial crises that she looks at with a different eye, having been a judge, and saying, look, here's some of your considerations. So our team at the firm, and we formed what we call our COVID-19 response team. And at the Tucker Arensberg website, we do have, as many firms do, a COVID-19 response. So if you went to the www.tuckerlaw.com, you would go in there and click on that link and see a lot of articles that are timely for clients, including issues concerning bankruptcy and insolvency. But so when we're looking at that, one of the things you have to say is, where am I today as a business? What are my needs? Where am I going?
I think a lot of us are now looking at that right now. We're actually looking at, hey, I don't see an immediate problem, but I can see 30 days or 60 days where there might be some cash crunch. So now's the time to start framing up your situation, right?
That's true, because one of the things is, if you think you need a bankruptcy is not something you should do at the last minute. Bankruptcy is like a chess game. You need to have planned out your moves before you get into the bankruptcy filing, because if you haven't planned it out, it can easily change course on you and take you in a way you don't want to go. Bankruptcy, you need to, one, be in a position where you have the cash to take you through the 30 or 60 days. Because even if you had clients, sometimes a bankruptcy can scare people off. People say, oh, they're in a bankruptcy. And you have different types of bankruptcy. If you think you're not going to make it and you want to control the liquidation of your assets yourself, Chapter 11 does give businesses the ability to file a bankruptcy and do a liquidation plan so they can do an orderly liquidation. Chapter 11 also has reorganizations, including the most recently amended Small Business Reorganization Act, which went into effect up until March. If you had debt of less than $2.7 million, you were eligible for that. We hear about Chapter 11, people talk about how expensive Chapter 11 is, and it is expensive. It's expensive for the debtor, it's expensive for creditors. However, Chapter 11, the Small Business 11, is supposed to be easier. You don't have a creditors committee, and a big cost in the Chapter 11, regular Chapter 11, is the fact that you have a creditors committee. And not only are you paying your lawyers and your accountants, you're paying the creditors committee's lawyers, and you're paying the creditors committee's accountants. And sometimes debtors feel that they're paying these lawyers and accountants to fight with them about where they want to go.
This is really adding up now. Absolutely.
It adds up very quickly. So the Small Business 11 was designed to take that out of the mix. There is no creditors committee in that Small Business 11. Additionally, because of the anticipation of so many small businesses having problems, they lifted the debt limits effective March 26 to be $7.5 million of debt. And it doesn't matter what your asset size is, it's the debt size which controls whether you're going to be in a small.
Okay, so it's all about the debt then. Okay, gotcha.
Yeah. So one of the things you have to do is you have to be in a position to be able to consult with your counsel. What are your assets? What are your liabilities? What are your executory contracts? What type of intellectual property do you have? Do you have licenses that have to be paid? Can you defer that? Do you have contracts which are burdensome that you want to get rid of? Because a bankruptcy lets you get rid of burdensome contracts. So you have all these factors that you have to go through with your counsel: cash flow, assets, and then think, where's my end game? What do I want to do in conjunction with the plan? Now, when you file bankruptcy, one of the first things that happens is there's an automatic stay that goes into effect.
Right.
The automatic stay stops all creditor action, all action against the debtor and property of the debtor. And property of the debtor is just about anything that you can think of in which the debtor might have an interest. So leases, real property, your accounts, everything. And the automatic stay, which is called, Section 362 of the Bankruptcy Code, stops all action. Stops your counterparties from terminating contracts. It stops lenders and taxing bodies from demanding payment. It does a lot of those issues. So it's a stay. Now, there are exceptions, such as police action. It doesn't stop the government from prosecuting you to shut down an illegal activity or anything like that.
Of course.
It doesn't stop the stay if you're an individual of the collection of support obligations like child support or alimony. And individuals can file Chapter 11. There's a big misconception, but you have a lot of mom and pop shops out there, and they're
Right.
not corporations, they're individuals, and they
So
do
it bleeds into
business.
becoming personal bankruptcy as opposed to being business bankruptcy sometimes.
But a personal bankruptcy, if a person's in business by themselves, they are the business.
Okay.
And they have the ability to file a Chapter 11 if they want to go that way. They can also file a Chapter 13 if their debt's not too high, but the debt limits in a Chapter 13 are lower than the debt limits in a Chapter 11. Yeah. For the main Chapter 11, there are no debt limits. For the small business 11, it's 7.5 million. That goes away next March. The debt ceilings will come back down to the 2.7 million adjusted for inflation.
Okay.
So that's something to think of. But if you're afraid somebody's going to take some kind of action, then the automatic stay stops them from doing that.
Exactly.
The next thing
comes.
Right. So they can't sue you. They can't send the sheriff out to take your assets. They can't stop the contract. Now, does it mean a creditor or counterparty has no rights? No, they obviously have rights, because the point for a Chapter 11 and a bankruptcy is the fresh start for the honest debtor. And what you're supposed to do is have a plan ultimately which makes for an even distribution to creditors. And so you have to protect the interests of creditors and secured creditors. So if you have debt, it's very important to be in the position, if you have a line of credit, to be in a position to be able to continue to borrow from that line of credit. That means having yourself in a position where you talk to your lender and make sure that they agree that you can continue to use your line of credit.
Absolutely.
If you have to continue to borrow, repay, and reborrow, that's a special type of action in the bankruptcy. You have to go in and get court permission if you're going to borrow on a secured basis. Regular trade debt, which is unsecured, you can continue to incur without court permission. And trade debt that it gets incurred post-petition after you file has a higher status. It's no longer just unsecured debt per se. It can have an administrative expense status.
What's that?
I'm sorry?
Yeah, what's that part? That sounds interesting.
Well, and bankruptcy has priorities. So like anything else, it looks at all of the debtors, creditors, and it prioritizes how payments are made to these creditors. An administrative expense is for an expense incurred by the debtor, which is ordinary and necessary to keep the debtor operating. And what that means is, after the petition is filed, administrative expenses get paid before unsecured creditors, generally. So post-petition unsecured trade debt is more likely to get paid than pre-petition unsecured debt.
Wow.
Right. So you do have the protection as a trade creditor of having your administrative claim paid. In a regular Chapter 11, it has to be paid on confirmation. In the small business 11, however, it can be paid over the life of the plan, but it has to be paid in full, unlike an unsecured debt. So the thing about a Chapter 11 is you go ahead, you form a plan as the debtor. You're going to pay your administrative claims. You're going to pay your secured debt. And normally you have to have agreements. You need to be in a position where you've spoken with your lender. You've negotiated the terms of either new loans or continuing to use your accounts receivable and inventory, which most of the time your lender has a lien on, even if it's term debt. And you can't just use it up without their consent. And they have to be protected. A lender has to be protected. A creditor has to be protected. And a debtor has to provide adequate protection so that the bankruptcy doesn't make their claims worse. All right. Absolutely. The whole point is a bankruptcy is supposed to put you and everyone else in a better position. You're supposed to emerge with the ability to repay. You don't want to be in the position of having a case where you all of a sudden have no collateral left for the creditor. So the creditor has recourse to say, well, show me that you're going to be able to replace my collateral if you use it. And that's called the use of cash collateral. And so a debtor can't use cash collateral unless it has the consent of the creditor. And if it doesn't have the consent of the creditor, it can still use cash collateral if they go to court and show that there's adequate protection of the creditor's interest.
I see.
So these are the things that you do on the first day of your filing, by the way. Wow.
That's a lot of stuff going on.
There is a lot of stuff going on. So bankruptcy is complicated, but for those of us who've been doing it for a few years, It's almost second nature.
Of course.
And so at the end of the day, the key is, what kind of plan can I put together to repay everybody? And you're looking for a plan under the small business case, or even the large one, where you're going to repay creditors from over 3 to 5 years.
Okay.
So that gives you the liquidity you may need, right? Because a lot of parties have issues not with respect to insolvency. They may have problems with respect to liquidity.
Liquidity makes sense.
All right. And then the thing about a bankruptcy is, when you're looking at how much you have to repay unsecured creditors, though, the repayment to unsecured creditors is, the test is they have to get more in that Chapter 11 than they would get if they were liquidated. So that's the best interest test. You just have to make sure that they get more in the 11 under the plan than they would have received in a liquidation.
Definitely.
And that's a really important test. The other big test is feasibility. The Judge Fitzgerald, who's my partner, used to come in and say, this is what she would call a WAP plan, a wing and a prayer plan.
Wing and a prayer plan.
Right. But you can't come in and just say, hey, here's my plan. I've always earned $10,000 a month. Next month, I'm going to earn $200,000, and that's great. These plans with financial projections that are hockey sticks don't necessarily work, and a debtor has to show that their plan is feasible. In a Chapter 11, that means that you have to show you're more than likely than not going to be able to make those payments.
Absolutely.
Right? And the thing is, you will have projections, you will have to have some financial information. It's also important when you're in a bankruptcy as a business that you have a good financial consultant who you trust,
right,
and who can know your finances to.
They have to go hand in hand with your lawyer, and that's why they become your two best friends at this point, because they're going to be working together to make a plan that's going to be workable, right?
Absolutely. As a lawyer, and the thing is, you have to retain your lawyer. The court has to approve retention of your lawyer and your financial professionals. And it's really important to have a financial professional who understands your business, who can understand where you're going, because you're going to need them to help you with your cash flow plan. You'll need usually a 13-week cash flow for your cash collateral motion. You'll need financial projections for the plan to show the plan's feasible, and that also that creditors are going to get at least as much in that plan as they would in a Chapter 7 if the debtor were liquidated. So that's what you use your expert for.
Right.
The other thing is the chapter plans. So then you look at your leases and executory contracts. You have to decide, am I going to assume these? Am I going to reject these? All right. Now, with respect to leases, if I'm the debtor and I'm leasing property, at some point in time, I have to start paying my lease. The bankruptcy code doesn't give you a free pass to not pay your ongoing expenses.
I think a lot of people might be confused by that too. I think sometimes feel like, oh, I filed bankruptcy, so like I'm free. And it's like, no, you're not. You're being protected. That's it, right?
You are being protected, and you probably can decide if you have a lease that you think is too expensive, and that there's huge damages that would be involved if you breached and moved out, but you thought, oh, I should go to smaller space. The bankruptcy does give you the opportunity to reject that lease, and then their damages get paid as an unsecured claim.
Right. So Beverly, I have a question for you. Before someone actually has to file bankruptcy, say like, I mean, just with the current situation that we're in, we're seeing lots of folks within the course of like 3-4 weeks, like the carpet's been pulled out from underneath them. Is there an ability before filing any bankruptcy or going down that road to just talking to some of your creditors and saying, hey, I'm going to be slow. We're in a pandemic here. I intend to pay you. Is there a strategy around that first before just going down the bankruptcy road?
Oh, absolutely. And in fact, your first strategy should always be to try to address your financial problems outside of a bankruptcy setting. Bankruptcy is there if you think you are going to need it because your creditors are not working with you outside of the normal restructuring.
Right. It has to be last ditch, right? At the end of the day, like bankruptcy is something where you got to exhaust these things first and try to talk things and
bankruptcy it's a strategy. Yeah. All right. It shouldn't be your last ditch effort. It should be a strategic effort to accomplish the goals that you may need to accomplish. It can be a strategy to right size your balance sheet. It can be a strategy that your creditors actually want to see you in a bankruptcy so that you can sell your assets through a bankruptcy plan or through a sale.
Okay.
All right, so it can be a strategic. I've been in cases where we've been doing restructuring with a borrower, and the borrower wants to sell assets. Well, in a bankruptcy case, you can sell assets free and clear of liens, even if and just the liens attached to the proceeds. So one of the benefits for secured creditors is you get a buyer, there's a sale process, they get the proceeds, and some money is carved out for unsecured creditors, and it happens much more quickly than you would want. So it's a strategic process. It shouldn't be last minute. If it's last minute, your ability to succeed is probably not great. All right.
I think one of the main points you've really brought here is that this is a long process. You must be very thoughtful about this, very open and communicative about it as well too, and it's very strategic at the end of the day as far as that goes.
With respect to lenders right now, what we're seeing from our clients, most of the lenders, most of the banks, they are in the position to try to do deferrals or forbearance agreements.
Right.
So if you're having problems because you don't have cash, you should definitely try to be in the position where you don't default on your payment.
Right.
It's really critical that you be considered current for purposes of going to a bank and asking them to help to defer payments. Most of the banks, and that's because of what's called a troubled debt restructuring, a TDR. The Federal Reserve, as part of the COVID relief, has eased up on TDR reporting. And that way a bank, it used to be if you were not current, then the bank would then have to reserve against your assets on their balance sheet, which affected their capital. So banks were very reluctant to do that. The Federal Reserve has eased those requirements, so a bank, as long as you're not classified as troubled already and you're current, the bank will probably defer. A lot of banks are doing simple deferrals for 60, 90, 120 days, I think, on the request.
Yeah, they're basically seeing that they're not going to get blood out of a stone, so at least try to defer it and see if people can come back and start making those payments again and get caught up as far as that goes. It's just a crazy world out there, and I'm so glad we got to talk about some of this stuff, because I think our listeners and our viewers out there I think getting this key information to know that you got to be strategic about this. You got to be thinking this thing through. And best of all, the professionals like you out there that can help guide them through this. Like you said, for you, this is very second nature. For many people, they've never gone through a bankruptcy before. And it's probably one of the scariest things in the world you're ever going to do, because it's pretty traumatic. But at the end of the day, it becomes a tool to use to get you to a better place, right?
Right. Well, the other thing that people have to think about is, even if they're not going to file bankruptcy, they may get involved in a bankruptcy if one of their big account receivables files bankruptcy.
Right.
So
they can be the creditor,
if that
not the debtor,
happens,
right?
Then you're still talking to bankruptcy counsel. You're talking to someone like myself or my partner Jordan Blask about being on a creditors committee. These are all the types of things. So bankruptcy, it's not just you where you may need to talk to us. It may be you because you want to file for yourself. It may be because you won't have a big account receivable and now the debtor's filed bankruptcy. And how do you get repaid? If you're a landlord and your tenant files bankruptcy, what are your rights? If you hold copyrights and trademarks and your licensee files bankruptcy, what are your rights? These are all things you have to think about. The thing about bankruptcy is it moves quickly. You don't want to wait till it's 6 months down the road, because then the die will be cast and you may not have protected your rights. So you have to act promptly, figure out what your rights are, and say, hey, these are my rights. These are how I'm affected. This is what the law says can't and cannot be done with respect to claims and interests that I would have. So we're here.
Absolutely.
Pittsburgh has a very collegial bankruptcy bar. Our judges in the Western District are great. We have a complex Chapter 11 procedure that was put into place a year and a half ago. I was on the committee that helped put this into place in Pittsburgh. So the judges are prepared in this district, if a bankruptcy gets filed, to handle issues quickly.
Excellent.
And that's why, as a creditor, you can't sleep on your rights either. You have to respond quickly as well.
Good information. I cannot thank you enough for giving us all this information. I really encourage people that want to learn more, go to your website. What's your site again?
www.bankruptcy www.tuckerlaw.com.
Tuckerlaw.com. Check it out because I know you've got lots of good information. Even going through your COVID site, there's some great information on there as well too. Beverly, thanks again for hanging out with us here on the Tech Vibe Radio One Mic Stand. You're the best.
Thank you so much. It was fun.